You reserved an hour. I'm going to give each side 30 minutes. I reviewed the motions and the responses, which I appreciate. So if you have anything to add to that, each side has 30 minutes to tell me whatever you'd like to tell me. All right, so I'll start with City.
Thank you, Your Honor. Matthew Mandel. Approach the podium, sir.
You can actually sit there if you want, just talking to the microphone. Sure.
Wait a minute, you're gonna sit there, let me move, so I can see you. Sorry, Judge.
Okay.
It's okay.
Your Honor, just so the record, the only defendant is remaining is the city.
I was just reading the caption
Yeah.
of the case. Yeah.
Okay. Look, as the court is well aware, this case has been going on for quite some time. We're now on a fourth amended complaint. The last time we were here was on October 18th, 2018, and the court dismissed the lion's share of the plaintiff's complaint against all the individual defendants and whatnot, and the only claims that survived were documents that are being requested as we'll call them request number 4 and 6. Those were the videos that we had talked about, and also to the extent that the plaintiff is challenging excessive charges. In the replayed complaint, Your Honor, the excessive charges related to requests number 2, 4, 5, 7, 11, and 12. Basically, what he's contending, all these documents, by the way, have been produced in response to these requests, some of which he was charged, some of which he wasn't. The plaintiff paid approximately $435 in total for all of the documents. And he's claiming basically where our case is at right now is the videos under request number 4 and 6 have since been produced since our last hearing, Your Honor, unredacted. He's admitted that. So really, all we're here now is the lawsuit has been boiled down to him claiming that some of the amounts of the $435 that he paid, $435, less than the cost to file a lawsuit, and some of that is excessive. That's what we're here about. That's what the lawsuit is still alive about. He filed his Fourth Amendment complaint, and then on December 7th, 2018, prior to the city even having an opportunity to answer, he moves for summary judgment, asserting that there are no factual issues. He's ready to go, and let's get a hearing on this. The city filed its answer, did some limited discovery, request for admissions for its own summary judgment, which the city did file, and the parties now have both a motion set for hearing before Your Honor on June 4, 2019. Plaintiff is insisting before on his motion for summary judgment as well on June 4, 2019. So despite asserting that that there are no issues of fact, and that his insistence on proceeding to a summary judgment motion, Dr. McDonough is seeking the deposition of the city clerk and my litigation partner, who's counsel of record in this case, Sam Zeska. Our motion, I think, was pretty clear. There are no issues of fact, and he's asserted there's no issues of fact, and insists on proceeding on his motion for summary judgment. He can't now say, well, it's not right yet, there are issues of fact, and then so for purposes of getting discovery, and then on one hand, and then on the other hand saying, there's no issues of fact, we're ready to proceed on our summary judgment motion. It's one or the other. So right now he is proceeding with his summary judgment motion, and it's his position that there are disputed issues of fact. We don't think so as it relates to our summary judgment motion, but it's his position that it's not right to hear his summary judgment motion. He needs discovery and whatnot. Then that motion for summary judgment needs to be withdrawn. There's no basis for it. Again, as I said, there's no questions. He's admitted in request for admissions that we sent out that he did in fact receive the unredacted videos for response to request number 4 and 6. By the way, at no charge. We sent it to him at no charge. And he does not assert that he needs discovery to oppose the city's motion for summary judgment. There's been no affidavit filed by the city. If we had filed an affidavit in support of our motion for summary judgment, and he said he wants to depose the affiant, of course we make that person available, but we don't believe we even need an affidavit based on the undisputed issues of fact. No issues of fact. He also, when I asked him why he wanted to take the deposition of Mr. Zeskine and Ms. Sewell, he's pretty bent on the affirmative defense that the city raised, affirmative defense that he had filed the lawsuit for an improper purpose. First of all, we don't get there unless and until we ultimately prevail and actually seek attorney's fees. And candidly, I don't think that that defense is even appropriate as to the remaining requests that are still pending, because the remaining requests that are still pending all predated the 2017 amendment. The reason why that affirmative defense, we left it in there, was to preserve our ability after the lawsuit was over, because of the other requests post-2017 that have since been dismissed. So there is no reason and no basis to seek the discovery as to the improper purpose at this juncture. You know, he had filed his motion for order to show cause, basically because we did not appear for deposition. We had, in good faith, talked to him about that. We had filed a motion for protective order. We tried setting it for hearing at the time, unbeknownst to all the parties. I guess you had rotated out or whatnot, so we had to then go back before Judge Bailey, unopposed. We got it transferred back before Your Honor.
I was wondering how it got back.
Right. Oh, no, sorry. But we thought it would be, for efficiency purposes, Your Honor has had the case and was intimately familiar with the case, and it was unopposed, and we got it back before Your Honor. And once the order came back in transferring it, Dr. McDonough asked if we could get it, when could we get our motion for protective order arrested. His first available is March 21st. His motion counter, he goes, I don't want a motion counter, I want a special setting. And luckily, I guess we were able to get the special setting on April 5th. I told him I don't think we're going to be able to get a special setting. Your JA was accommodating to us. There was a canceling, so now we're here. So it's not that we did not, we just filed a motion for protective order and just sat back on it. I mean, we were diligently trying to prosecute our motion for protective order. And his basis for sanctions, or his order to show cause, is it's a little unclear. His motion looks like he's going after Mr. Zeskine and Ms. Sewell, and then in his reply, the attack is more focused on myself and my law firm and the criminal enterprises, our law firm supposedly, and all these patently false statements about our law firm. But it really comes down to, should the protective order be granted? And the answer is, it comes down to, if he proceeds with the summary judgment motion, Your Honor, the answer is absolutely, because again, he is represented to the court. There are no factual issues. So what discovery does he need? He hasn't even explained what discovery he needs that would even relate to the summary judgment motion. If he withdraws his motion for summary judgment, then at that point, any type of discovery, any deposition, we would suggest should be a corporate rep that relates specifically to the request at issue and the issues that are still remaining, specifically the overcharging issues. Nothing more, nothing less. There is absolutely no basis to depose my law partner as to public records that were sent to the city. Mr. Zeskine is again litigation counsel, and anything that you would say would be privileged. Mr. McDonough is going to say, well, public records doesn't allows for production of privileged documents. True, but it doesn't allow for the deposition and testimony, and requires anybody to testify as to privileged information. There's case law on that issue.
You want to respond to his argument that he wants to ask Mr. Zeskine about a allegedly false claim of plaintiff's intent to write a book on how to harass government agencies?
First, that goes to the affirmative. First of all, that was a pleading that was in a pleading that we filed when we had filed a motion to compel way back when, before the matter was transferred before Your Honor. That was in the motion to compel, and that related to documents that we were trying to seek from Mr. McDonough that related to our defense of an improper purpose for the lawsuit. Back when we had filed that motion to compel, the subject discovery request involved requests that were post the 2017 amendment that allowed for the recovery of attorney's fees. So what we were doing is we were seeking discovery to bolster our affirmative defense, as it relates to the improper purpose. Him asking Mr. Zeskine as to why he made a strategic or assertion in a pleading, that goes right to the heart of mental impressions. That's sacrosanct. He can't ask him any questions about that. And plus, what we filed in a pleading is there's immunity to that. I mean, for the same reason why I couldn't sue him for defamation for writing some of the things that he wrote in his reply to our motion in order to show cause. He can't seek discovery as to that, and that would be completely improper. So, with that, Your Honor, we think that it's pretty clear our position on the motion for protective order. I don't know if Your Honor wants to deal with the issue on the motion for protective order, and then we can deal with the.
No, I'd rather just 30 and 30.
Okay, so no problem. So we'll go down the motion to compel as well. Any other questions on the motion to compel issue? Thank you. And I do not think I'm going to be using my full 30 minutes.
That's okay too.
Okay. The motion to compel, basically, I mean, he takes issue and with our responses, certain objections, and certain responses, and I'll categorize it in 3 different areas. One is he has an issue with some of the objections that we launched as to requests that related to matters that are no longer involved in the lawsuit. And those dealt with requests number 1 through 5, 8 through 9, 15, 16, 20, 26, and 27. That's the first category. The second category, there were 3 objections that we had in response to requests for admissions 17, 18, and 28 that were calling clearly for legal conclusions or objectionable on that basis. And then the third category of response that he takes issues with is that 1.370 requires us to admit or deny or qualify, and he said that our denials are bad faith denials. Well, that's our response. There's no basis to compel us to change our answer. If he thinks that our denials are improper, then there are avenues for that. But there's certainly not a basis to compel. If we actually respond to the request for admission, we admit, it's not just like an answer. He doesn't think it's proper. Again, that's for him to go ahead and develop, but there's no basis to
I also
compel.
think the rule says that the penalty for, I'll put this in quotes, wrongfully denying something is you get your attorney's fees.
Correct. If they ultimately prove that it was an improper denial, that's the recourse under 1.370. Right. I agree. So let's talk about the request that had nothing to do with anything in the current lawsuit. Okay. Request for admission number 1. I'll just give me a second, Your Honor. I'm just going to go to the. It deals with request, the document request number 3, public records request number 3. Again, public records request number 3 is not part of this lawsuit. It was dismissed. Request for admission 2 deals with information related to request number 1. Public records request number 1. Again, public records request number 1 is no longer part of this lawsuit. Request for admissions 3 through 5 deal with, again, this whole issue regarding the pleading in our motion to compel, where we talked about Dr. McDonough writing a book, that issue. And again, it's our position that that is not, at least as the lawsuit stands today, with the current request for admission, that issue is relevant anymore. Request for admissions 8 through 9. Hold on one second. Bear with me, Your Honor. Request for revision number 8. Admit that Dr. McDonough, though not required to do so, sent follow-up emails to the city about request 1, 2, 3 in the initial action without production of records before filing suit. Again, has nothing to do with overcharges, and in fact it talks about 2 different requests that are no longer part of this lawsuit. Request for admission number 9. Admit that Dr. McDonough has repeatedly warned the city since at least 2015 that it was in violation of records law, which would lead to litigation if not corrected. Again, I don't know how that has anything to do with the withholding of the videos or the overcharging. So 15 through 16 were kind of vague, and we rejected on it was vague, but we think that they're moot now anyway, because 15 and 16 both deal with what they call redaction of video issue. Given that we've now produced the videos, and he's admitted to that for no charge, we think that responding to this would be moot. 20 also deals with admit that at October 18, 2018 hearing, before Your Honor, the city, through its attorney, claimed at the time to review the requested dash cam, or request number 4 was required because the city reviewer had to review 24 hours of video. Well, obviously, we think that that's no longer pertinent, given that we produced the video. Plus, what we said is what we said. What's on the transcript is what's on the transcript. And request for admissions 26 and 27 deal with a separate, unrelated case. Really, kind of what tipped off this whole thing, his issue with City Officer Marguido, and it was an appeal between Mr. McDonough and the city, and he wants information relating to emails between Mr. Zeskine and my appellate law partner, Ed Geddes, relating to a completely unrelated case that has nothing to do with this case, or any of the issues that remain. So those are the basis of the objections on those. 17 and 18, request for admissions 17 and 18. 17 is admit that the only case law possessed by the city supporting the redaction of video is Ramsey's. And again, he's asking for us for either legal conclusion or mental impressions, and plus it's moot anyway, given that we produced the video. Number 18, admit that the holding of Ramsey's upheld redaction video was appropriate under Florida Statutes 119.0714C for information revealing undercover personnel, not under Florida Statutes 119.0714D. Again, calling for a legal conclusion, a legal opinion on as to a statement of law, not proper for a request for admission. The last several requests, 10 through 14, 21 through 22, 24 through 25, he just takes exception, as I said, with our denials. In the interrogatories, Your Honor, he asked us simply state the factual basis for any request for admissions that you deny. Admittedly, we did not, through an oversight, we did not respond to 24 or 25 interrogatories on a factual basis for our denials. We have no problems supplementing and doing our supplemental interrogatory response to 24 or 25. We had thought we had covered that, but that was an oversight on our part. So we would have no issue with doing that. I think that it's fairly simple to do that. So with that, Your Honor, we think that our motion for protective order should be granted. We think that the motion for order to show cause should be denied. And we also think that the motion to compel should be denied. Certainly, sanctions should not be awarded against the city, Mr. Zeskine, the city clerk, Ms. Sewell, or the city's law firm. I will reserve. I've only used about 18 minutes. I'll reserve in case I need to reply. I will thank the Dr. Dennis. All right. Thank you. Thanks. Go ahead.
How are you doing today, Your Honor?
Great, thanks.
Just wanted to, before I get into what I prepared, I want to address his arguments about summary judgment and me claiming that there were no factual issues. When I filed for summary judgment, there were no factual issues, or no issues of fact that I considered at the time. However, since then, they have raised issues in their affirmative defenses, as well as their answer in their affirmative defenses. And not only do they contest and deny all my factual allegations, which are supported by objective evidence, they bring back up the fact that they're now claiming again that I filed for an improper purpose, which Mr. Zeskine originally claimed based on his false statement that I was going to write a book, which he has no proof to support whatsoever. They've gone even farther, and they're now accusing me of conspiracy, which is absolutely ludicrous. Furthermore, in their motion for summary judgment, although they say it's based on law, they do make factual allegations in there, and I can test their factual allegations. Since the factual allegations of my motion for summary judgment are contested by them, and their motion for summary judgment, the facts are contested by me, neither one of them is proper until we finish discovery. It would be premature. Earlier in this case, when I tried to move for summary judgment, opposing counsel made the same argument that because they were contesting my facts, that it was premature. I don't know why it would be any different now than it was then, other than the fact that they wanted to deny me my ability to get discovery. As to me deposing Sam Zeskine, I wanted to ask about many things, including also how they interpret my records request. In the other hearing before, the other case that was heard before you, Your Honor, they claimed that they literally interpret my request. But throughout the course of me filing records requests to the city, they fluctuate back and forth. They go to read them very narrowly, to read them broadly, to read them liberally. They read them however provides the greatest detriment to me. Also, Mr. Zeskine, or Mr. Mandel, opposing counsel, is claiming that because they provided me unredacted videos to request 4 and 6, that that's moot. And he makes a big issue that they didn't charge me. To begin with, they did charge me. And I did pay them. And they charged me for redacted videos, which I paid for. They're now giving me unredacted videos, which is a civil email. It takes no time. But furthermore, we haven't determined the lawfulness of those redactions, and them claiming it's moot and them producing the records is just to try to avoid having this matter under review, where I believe absolutely them redacting videos should be reviewed and the lawfulness of that should be determined. Your Honor, we're here today because the city continues to play fast and loose with both myself and this court after its statutorily delegated authority was activated. It's undisputed that this court has broad discretion to control discovery. However, as seen in Lore v. Smith, 464, SO2D, 1330, 1333, Florida 2nd, DCA, 1985, in such a situations in public records requests as the one at Bar, where the city has played fast and loose with discovery, the appellate court held that, or played fast and loose with the court or me, it held that discovery is proper. Further, the city, in bad faith, has abused the process in the first round of discovery, particularly when Mr. Zeskine falsely claimed that I had made a statement with an intent to write a book to teach people how to harass government with public records requests, which is absolutely false, and I absolutely contest that. This was done merely to support their baseless claim that I had filed with an improper purpose, and for this, their claim they made, I was actually granted a protective order from the city's discovery in front of Judge Diaz in this case. The city then failed to respond in good faith to my first round of discovery. Furthermore, the city has gone so far as to block and prevent or delay my obtaining information that they even refused to comply for 6 months with a written order from this court demanding protection or production and filing of a simple fee request list. I've cited the fee list several times now in exhibits here. That was pertinent to us determining if they had overcharged me or not. It was a one-page document, but from the time the judge first verbally ordered and then 2 months later written order, it was 8 months delayed to provide me with a simple fee list, which I repeatedly sent requests to Mr. Mandel to provide, which he repeatedly refused to provide. Moving into the present, after I filed my motion for summary judgment, the city filed its answer and affirmative defenses, where it essentially contests all of my facts and allegations. Further, the city has made scandalous allegations, again accusing me of filing for an improper purpose, and now alleging that I'm engaged in a conspiracy. Of course, the city's allegations in denial are all unsworn with no evidence to support any of them. The city then again initiated discovery, sending me their requests for admissions and related interrogatories. Much of their written discovery was directed at their claims for conspiracy and improper purpose. Though having been granted a protective order blocking their discovery, to keep the case moving forward and not creating further delays, I responded in good faith to their written discovery requests. At the same time, I propounded my own requests for admissions and related interrogatories, and the city again failed to respond in good faith to my written discovery. The city then requested dates to take my deposition, and available dates were provided to them. I later, after realizing they were just trying to use this process to abuse me, I decided not to give my deposition, but notified Mr. Mandel that I wanted to take Elizabeth Sewell's deposition and Sam Zeskine's deposition. Mandel responded that as I participated in written discovery, they had a right to take my deposition, but no longer needed. The city then quickly filed its motion for summary judgment and now wants to block completion of my discovery, though they too have participated in sending and responding to written discovery requests. The entire litigation of this case, they have acted as if what's good for the goose is not good for the gander. They attempt to repeatedly turn 119 upon its head, demanding they have a right to private records, but then claiming I have no right to public records. This court should either force the city to comply in good faith with all of my discovery and enter sanctions preventing the city from offering any evidence or testimony and from making any claim that I filed this request for an improper or frivolous purpose. Regardless of the course taken by this court should order the city and the witnesses to pay the costs I incurred when they skip the depositions and order the city to pay upfront any future cost of discovery, including a special master to oversee discovery, which I'm now respectfully requesting. If you look at the supplemental packet that I gave you, the second one, on page 9, it's their response to my admissions, and it might be easy for you to follow that. And I highlighted all the specific admissions that I want to discuss. So, Your Honor, first I'd like to discuss my motion to compel for better discovery responses. In tab 9, as I just pointed out, you'll see the request for admissions. I highlighted the ones that I want to discuss. In its response, the city failed to follow the instructions provided and provide any documents supporting their denials or any qualified admissions, and to identify any witnesses with knowledge of the denials or qualified admissions. Interestingly, the city objects to the exact same instructions they provided me with, which I believe is just another sign of their bad faith response. I didn't make up these instructions. I copied and pasted their instructions, and I followed their instructions to a T. I even in good faith called Mr. Mandel because I did not have the address and contact information for one of the witnesses that I believe had information of my denial or qualified admission, and asked Mr. Mandel, where he told me if he didn't like it, he'd let me know. However, again, he doesn't want to extend to me the same courtesy. Also, the city failed to verify its responses to the interrogatories, making them essentially useless. Clearly here, again, the city thinks what's good for the goose is not good for the gander. So, as to my admissions, the city objects to the relevancy of admissions 1 and 2. First, I don't believe the city gets to pick and choose what it thinks is relevant to the presentation of my claims or my defenses to their frivolous assertions. Second, the city's refusal to provide requested records until after I was compelled to file the first suit to force their compliance itself is unlawful. It makes me eligible for reimbursement of my costs of enforcement, and is evidence discrediting the city's argument that I filed my request or this action for an improper purpose. Therefore, these requests for admissions are relevant and are reasonably calculated to lead to discovery of missing material. Additionally to those 2 requests that I admit that the basis of the requests were dismissed, in requests 4 and 6, they again provided me the documents after the claim was made, which is a violation itself of the law. Further, I only asked for these admissions because the defendant has continued to assert that it never refused to produce documents, and claims that it had given me these documents before they were forced by this court under Judge Bailey to do so. And the claims they continue to make are false claims, which I should have a right to be able to get discovery for those. Again, as such, these requests for admissions are clearly relevant to the remaining issues and reasonably calculated to lead to discovery of missing material. The city objects as irrelevant my admissions for numbers 3, 4, and 5. These requests related directly to Mr. Zeskind's knowing and false claim that I had stated an intent to write a book to teach people how to harass government entities with public records requests. It was a false statement by Mr. Zeskind, which was used to demand access to all my personal communications and to claim that I filed my request for an improper purpose, and the city was entitled to its costs for attorney fees in this action. As of February 15th, in this case, they spent over $164,000 they billed their clients as they continue to churn this case and delay it. So further, as such, these requests for admissions are clearly relevant to the issues what the city has raised, and again raises in their answer and affirmative defenses, and are reasonably calculated to lead to the discovery of admissible material. The city objects as irrelevant admissions for number 8 and number 9. These requests relate to the fact that I had sent repeated follow-up to my request, though I'm not required to do so, and that I had repeatedly warned the city that it was in violation of the Public Records Act. This further demonstrates I was not trying to trick the city into violating the law, and I was hoping for compliance and to avoid any unnecessary litigation. As such, these requests for admissions are clearly relevant to the issues which city has raised and are reasonably calculated to lead to the discovery of admissible material. In admissions 10 and 11, in the corresponding interrogatory to admission 10, the city denies that the 53,000 records they identified as responsive to request 5 were already publicly published by claiming that it is likely that there were messages and other data which had not been posted publicly on Facebook. The city doesn't say that there were no such records which were published, only that there likely were some. Your Honor, request 5 explicitly held copies of documents and records related to Homestead Police Department's Facebook page. 1, who controls, monitors, deletes, etc. 2, rules, regulations, guidelines established for updating and deleting content and controlling access to post, comment, and like. 3, under whose orders or directions were my posts deleted and access denied or restricted. 4, what is the legal justification for such deletions and restrictions? 5, why have entire posts, not just comments, taken down? And 6, why was the review section taken down? Your Honor, clearly some of these requests fall into the category of questions and not actual requests for records. However, even assuming they were all requests for records, it's unfathomable to imagine there being 53,000 records responsive to this narrowly targeted request. It's unlikely that even 100 pages are responsive to this request. It's obvious that the city interpreted my request in an overly broad manner to inflate the time and increase my cost of production. Further, it would not be proper to charge for review and redaction time to review things which were publicly posted to the Facebook page. It should be clear that the city improperly inflated the cost of production. Additionally, the city never gave me an updated invoice when I made it clear I was not looking nor asking for any Facebook posts or comments. To this end, the city regularly changes how it interprets my request for records, shifting from being overly narrow and not providing records, which is clear that I'm looking for, to being overly broad and inflating my cost. Their changing interpretation is always, every time, to my detriment. Overbilling as done in this request is a central issue of this case, and the city is trying to avoid showing that it has indeed overbilled me in responding to my records request. The continual fluctuation in how records requests are interpreted is also seen in a new case I filed, case 19-06869 I filed last month, where the city now has 5 different times provided me with records responsive to my request, and it's still not believed that all the records have been produced. So I asked for a certain set of records. They narrowly construe it to be much narrower than the records I'm asking for, and I've had to call them out 4 separate times for not giving me the records, which has led to 5 separate sets of production of records. In admissions numbers 12 and 13, the city denies that it has a policy of charging $45 an hour. However, it admits that it charges this amount, and has further provided a fee list showing that it charges this amount. The city denies that there is a combination of salary and benefits which totals the amount of $45 an hour by simply claiming there are combinations which exceed this amount. However, the law requires that any charges levied reflect an actual cost incurred on the city. Furthermore, even though there are combinations of salary and benefits which exceed $45 an hour, this is more than the total compensation of the IT coordinator for the city and in excess of the total compensation for their computer programmer analyst. Certainly someone at or below the level of the IT coordinator or computer programmer or analyst can do a simple email search, again showing the city has unlawfully inflated the cost of my obtaining records. In admission number 14, the city admits that it inflated the ITS time in an invoice, but then preposterously and without evidence or support claims it had accurately prepared the invoice, the cost would have exceeded the amount actually charged. Whether or not the invoice related to request 2 was inflated is one of the central issues of this case. Without support for the city's claim, it must be disregarded, and plaintiff's allegations that the city unlawfully inflated the hours required and or inflated the hours at a higher rate must be taken as true. Again, they failed to provide me with any records showing how much time was spent on my records request, who did the work responding to my records request, or what their total compensation is. In admissions number 15 and 16, the city objects is vague and ambiguous that they have a policy of redacting footage of police officers from video, and it claims a right to make such redactions under 119.071-4D. However, the city clearly knows what's being asked in here and simply refuses to admit that it has an unlawful policy of redacting non-exempt information from videos. In admission number 17, the city objects, claiming plaintiff impermissibly seeks a legal conclusion.
Wait, you have to slow down, please.
And for seeking work product protected information. Asking if the city has any case law other than Ramsey's v. Demings is not a legal conclusion. Furthermore, case law citations are not protected work product as it was not prepared by an agency attorney or at the express direction thereof. Further still, published case law citations do not reflect a mental impression, conclusion, litigation strategy, or legal theory of the attorney. Additionally, why would the city not want to settle the matter of video redaction unless they know that they're incorrect? In admission number 18, the city objects is impermissibly seeking a legal conclusion, admitting to the fact that Ramsey v. Demings upheld redaction of video under 119.071-4C for revealing information of undercover law enforcement and not under the exemption they claim 119.071-4D, which exempts only photographs of current and former law enforcement. That the city refuses to admit such is telling. Further, it should be noted that while opposing counsel chastises me for citing a section of case law that was not in the holding, they have done the exact same thing here with Ramsey, which I have a copy of I can provide if you would like it, Your Honor. In admissions numbers 20 and 21, the city refuses to admit that it claimed as support for charging the 17.25 hours of time for request 4 or request 4.1 that it had to search through 24 hours of dash cam footage, and further denies that plaintiff had asked for only dash cam of a specific arrest by a specific officer on a specific date at a specific time. This is absolutely relevant to my claim that the city inflated the time, leading to unlawful excessive charges. As such, these requests for admissions are relevant to the remaining issues and reasonably calculated to lead to the discovery of admissible material. In admission number 22, the city denies the majority of the 4 hours charged for redaction of video in request 6. However, the city has now demonstrated a pattern of it once again failing to provide any evidence to support its claims. In its corresponding interrogatory, the city disingenuously asserts that also requested were the personnel files of 3 officers, while it admits that it billed me separately for those records. And it admits that they claim that in request 6, I also asked for a list of officers attending the council meeting. However, no such list was supplied. I paid almost $100 for that request, and what they gave me was a redacted video that was approximately 2 minutes long. In admissions number 24 and 25, the city denies that it has failed to waive the first 30 minutes of time in many of my requests for records, and denies that it has charged me for copies of electronic records requested to be electronic and provided in electronic format. However, again, the city fails to provide any evidence to support its claim, and I have evidence refuting their assertions otherwise. These admissions are directly related to my claims the city has levied unlawful excessive charges. Further, the city failed to provide corresponding interrogatory response for this one. And as well, where they didn't, for all denials and qualified admissions, they were required to provide an interrogatory response. The interrogatories also required them to provide any evidence that supported their answer, as well as identify any witnesses who had knowledge of this. This is the same burden they placed on me when they filed discovery, but they don't want to meet the same burden themselves. In admissions number 26 and 27, the city objects as irrelevant in emails showing the attorneys for the city were attempting to hide material facts from this court, from you, Your Honor, in the related case heard before you. However, the evidence of the city attorneys attempting to hide facts from the court, which I allege has been done in this case as well, is purely relevant to my assertion that the attorneys for the city have a pattern to mislead you in this court and or to perpetrate a fraud upon this court in my public records cases. This is relevant to both the claims I'm trying to make and in my defense against the false allegations being made against me by the city attorneys. In admission number 28, the city objects as irrelevant my question about the statute of limitations. However, this is relevant to the remaining issues in this case, as if the statute of limitations had run out and the claim of attorney work product is no longer valid, and this violates the law both in preventing production of non-exempt records and by levying excess charges for review time, which is not required. Therefore, it is relevant to my claims. Next, I would like to address the motion for protective order. First, the city, not the non-party witnesses to be posed, are who filed this motion. Regardless, this filing was not made in good faith. This is shown in that it was not filed until well after the notices were sent and after Zeskine had been subpoenaed. Further, the city made no attempt to set a hearing for this motion. Furthermore, the motion is not legally sufficient as good cause was not shown and no affirmation was made as required by law. Whereas the unsworn representations of an attorney have no evidentiary value. Additionally, city and its attorneys have been playing fast and loose with me and this court, and as such, my obtaining discovery is proper. Not to mention, I should be able to defend myself from the false and baseless claims made by the city attorneys. As to the deposition of Elizabeth Sewell, the city knows that she was properly served. The city's argument otherwise requires a willful misreading of the case law which they have cited. As to the deposition of Sam Zeskine, he can be compelled to appear for deposition in Miami-Dade County, and it's absolutely clear that he transacts business in person here in Miami-Dade County, which is all that's required under Florida Rule of Civil Procedure 1.410E2. They're claiming I cannot depose Zeskine in Miami-Dade because he does not live or work in Miami-Dade. Mr. Zeskine has been present here at every hearing in this case. He has billed the city for these hearings. Clearly, he's here in person transacting business, which is all that's required for me to be able to compel him to appear for deposition in Miami-Dade County. Further, contrary to the assertions of the city, I'm not going after attorney-client information. His communications with the city in responding to my requests, such as the redaction of video, is not attorney-client protected. Attorney-client privilege does not generally apply in public records cases as seen by the cited case law, and material prepared without a pending lawsuit or the threat of an imminent one is not protected under attorney work product provisions either, Your Honor. To any extent questions asked during deposition would be privileged, it's based on the knowing false statements Zeskine has made about me, including his claim of me writing a book on how to harass government with public records requests, and the privilege should be waived under the crime fraud exemption. Not only is his false statements demonstrate that he has sensibly set forth an unconscionable scheme meant to unfairly influence a trier of fact, it also unfairly hampers the presentation of my claims, which I consider to be fraud as a definition of fraud upon the court, as well as actively trying to prevent me from accessing public records I have a right to, is criminal. I understand I have no right to get redress for criminal matters here. However, I do believe that he's conspiring with his clients to block my access, which is criminal, and I should have every right to be able to get discovery on that. Lastly, I would like to address my motion to show cause. The city would claim that I unilaterally set the depositions. However, this is not true. I attempted to confer in good faith with Mr. Mandel, but Mr. Mandel refused to reply. In the first deposition I took in this case, the city delayed for months before responding to my effort to confer to set the deposition. I should not have to be continually delayed by the city in prosecuting this case, only to have the city then later turn around and claim that the case should be dismissed because it's taken so long, when it's repeatedly opposing counsel who's created all the undue delays, which have been months long in most instances. So therefore, to avoid such a situation of opposing counsel creating further undue delays, I emailed opposing counsel to confer on a time and date for setting the depositions. I clearly informed opposing counsel and the non-party witnesses if they did not respond, it would be understood that they had no intention to cooperate, and I would set the depositions at the time most convenient to me. Opposing counsel and the non-party witnesses refused to respond, so I set the deposition myself as they had been warned. Further, opposing counsel knows that a subpoena cannot be ignored without prior action of the court. Further still, opposing counsel knows that a motion for protective order is meaningless unless the court has actually issued the protective order. However, opposing counsel proceeded to interfere with the non-party witnesses anyway by instructing them not to appear for the deposition. The non-party witnesses were properly subpoenaed and based on instruction by opposing counsel failed to appear. Therefore, the city, opposing counsel, and or the non-party witnesses should be required at a minimum to pay my costs incurred in the skipped depositions. Additionally, the non-party witnesses should be compelled to appear for depositions, and if they cannot provide good cause to justify their non-appearance, they should be held in contempt of court. Further, I respectfully request the non-party witnesses be incarcerated with a PERD provision to force their appearance at deposition. In conclusion, I note the following. I filed a second request for production of documents in this case, which is actually due today. However, the city has not yet provided it. Maybe they're planning on providing it at 11:59, but I would hope that they would comply with that in good faith. If not, we're going to be right back here again, wasting your Honor's time and this court's precious time and resources for their willful, bad faith reply to my discovery. The city should be ordered to provide a complete transcript of October 18, 2018 hearing. It appears Your Honor ordered the city to cite and attach the transcript to the proposed order, which they failed to do. Further, in the certification of the transcript by the court reporter, Ms. Laurie Seskine, it's claimed that the partial transcript provided is a true and complete record of her stenographic notes. This is a false claim, and it's obvious the transcript is not complete. And again, I would respectfully request that you order them to provide the full, complete transcript and file it with this court as you had instructed them to do at the October 18, 2018 hearing in this case. Providing the full transcript is important, as opposing counsel is now using the order to knowingly and falsely claim that you, Your Honor, dismiss with prejudice all claims, including declaratory and injunctive relief, while willfully ignoring the fact that you explicitly excluded dismissal with prejudice for the video redaction issues of requests 4 and 6 and the overbilling. In the partial transcript provided, you can see that in the supplemental section I gave you, 8C. I want to read what you stated, Your Honor. I'm granting the motion, except as it relates to requests 4 and 6, which is the video issue that we have been discussing, and except as it relates to the amounts of charges that the plaintiff is contesting as to their reasonableness and the amounts. And that would include dismissal with prejudice of the injunctive relief and declaratory relief claims, except to the extent we are talking about those issues, the redactions and the excessive charges. If you go, I've highlighted everything I wanted to point out. If you go down further in page 4, you state to Mr. Mandel that you're sure that he will accurately memorialize your ruling. He willfully wrote the order in a manner that he could later then falsely claim what it meant against what you had stated. And then lastly, you said that he can say for the reasons and incorporate the transcript of the proceeding dated October 18, 2018, which again, that he has failed to do. In his motion for summary judgment, he's claiming that I have no right to relief and my case is moot because you dismiss with prejudice all claims for declaratory and injunctive relief, but it's very clear, based on the transcript and the order, that even though claims for declaratory and injunctive relief were dismissed with prejudice, excluded from that dismissal with prejudice were the issues of the redaction of video for requests 4 and 6 and the overbilling. Furthermore, based on the evasiveness and bad faith of city's responses and actions, they should be either forced to comply with all my requests for admissions in good faith, and I should be allowed to take depositions, or alternatively, the city should be sanctioned by prohibiting them from offering any evidence or testimony to support their baseless assertions that they have complied with the law. If you do not want to sanction the city by prohibiting it from offering any evidence or testimony, then I should be allowed to complete my discovery, including the taking of depositions. The city should be forced to pay upfront the cost thereof, and I request that this court delegate the remaining discovery to be overseen by a special master, which the city should pay the full cost of to prevent them from wasting any more of this court's precious time and resources. Your Honor, I thank you for your time, and if possible, I will reserve any remaining time I have for rebuttal.
Anything else, Lance?
Your Honor, the order that was signed by Your Honor that Mr. McDonough objected to specifically says in paragraph 3 that I drafted, you signed, that he objected to. It says plaintiff's claims against city relating to requests 4 and 6, as they are identified in the third amended complaint, are dismissed without prejudice. Plaintiff's claims against the city relating to alleged overcharges are likewise dismissed without prejudice. And it was clear that we reflected the order. It was accurate. He actually objected to that, despite the fact that he just read that same language from Your Honor. I think what's poignant, Your Honor, is he has not explained at all why he needs the discovery as it relates to either even his motion or certainly our motion. And we stand on all our arguments as it relates to our motion for protective order and also in response to his motions for orders of cause, as well as his motion to compel. Thank you, Your Honor.
All right. Thank you all very much. I'm going to take it under advisement, and you receive an order from me. Thank you.
Thank you, Your Honor. You have a great weekend.
You too.
All rise. Oh, Your Honor, I'm sorry, real quick. I just a case for the record. I made mention to something. I just wanted so it's clear for the record. It's the State versus Coca-Cola Bottling Company. I referenced how the Florida Public Records Act, while it allows for production of privileged communications, it doesn't allow for testimony. Specifically, the last paragraph of the opinion, it was on a petition for a writ of cert. It said that the trial court did depart from the essential requirements of the law and deny the motion, with regard to Coca-Cola's request to take depositions of state representatives who are knowledgeable of the Pepsi-Cola matter. Section 11907 only pertains to disclosure of public records. It does not cover oral testimony. Accordingly, petitions granted into that portion of the order because the state's representatives are exempted under the attorney-client privilege pursuant to section 90.502.
Thank you.
If I could, I would-
And the site is 582 Southern Second 1. Okay, thank you.
if I could, I would just like to note that Florida statute 90.502 doesn't apply to public records. They claimed that in other related case, and then they recanted on it after they came to that conclusion. Furthermore, it's beyond clear that the city has played fast and loose with both you, Your Honor, and me, and under Lorraine v. Smith, in such situations, discovery is proper. So I would ask to be able to complete discovery or them be barred from entering any evidence or testimony.
Okay, thank you, Judge.